Good evening. We are delighted that so many of our Notre Dame scholars and students have joined us this evening for this conversation with Tom Arkell about immigration and employment options for graduate students, researchers, and postdocs. My name is Leah Zimmer. I'm the director of the International Student and Scholar Affairs Office, and it's our pleasure to always provide resources to help our international students, scholars, and postdocs navigate the U.S. immigration landscape. And I think you'll find this conversation, this presentation by Tom, to be really helpful as you consider your next steps. Just a few housekeeping items. The first is we invite your questions. We hope you have come with a few questions for Tom to address at the end of the presentation. And we ask that you use the Q&A function to submit those questions. He will have some information about any follow-up opportunities that he has. We will be recording this evening's conversation and likely posting it on our website in the next week on the issa.indy.edu website so that you could come back to it if you missed something and have it as an ongoing resource for you in the coming months. So I will take this opportunity to turn it over to Tom. And Tom, thank you so much for being here this evening.
All right, thank you very much, Leah. Thank you very much for the introduction and for taking the time to organize everything. And hopefully it's helpful to the people who are participating today. Just as a little bit of background, I attended Notre Dame undergraduate in law school. I was there for 7 years, as we discussed briefly before the starting today. So I've spent many falls and winters in South Bend, and wish I was there in person, candidly, rather than just having a talking head here, as I've been there for many years in a row. But I'm happy to be participating here today. Is a brief summary. I'm going to be providing some general information about the immigration process, and then get into more detailed information in terms of self-petitioning for permanent residence for PhD students, postdocs who may not be sponsored by an employer. The one thing I'd like to emphasize, first of all, is for everyone who's participating, is to make sure you use the resources that you have on campus. Leah and her staff are extremely knowledgeable at Notre Dame, so make sure you use the international office for questions that you have with regard to F1 status, J1 status, and issues regarding employment on campus. You don't need to talk to a lawyer about OPT or CPT. Those issues can be addressed directly on campus, and I encourage you to use those resources on campus to help you with those specific issues. In terms of the updates, there's been some good news. Leah and I talked just briefly before we started today, but there's been a lot of positive things that have happened within the last year or so. The previous 4 years were a bit of a challenge for people from other countries, but there's a lot of positive news, which is nice. The travel bans have been lifted. So it's easier for people to enter the United States now. COVID restrictions, those will be lifted here soon in November, so it's going to be easier to travel. Visa appointments are starting to open up, so it's getting a little bit easier for people to get visa appointments. We've been helping people throughout the world get appointments at consulates and embassies, and that's becoming much better. I just had an individual who was in Toronto today who had their visa appointment and was approved and happy, which is a very rewarding part of our job. But those things are getting better. The used to be a public charge with regard to adjustment of status, the last stage of the green card, where the government was looking at whether you've had any type of public assistance, more closely about how much money made. And there's a very lengthy form that is no longer required, which is positive. There were interviews required for all applicants previously. It used to be just for family-based cases, but now, and then they added employment-based cases. So even tenured professors were having to go in for interviews. They're starting to waive some of those interviews for employment-based cases. At first it was for COVID, and now it seems that more as a standard operating procedure, although I did just prepare 2 professors from a different university earlier today for their upcoming interviews. So sometimes there are interviews, sometimes not, but it's definitely becoming less of a challenging process in terms of the interview, although you still need to be prepared. And if you've had any problems in your background, that needs to be addressed before the interview. There will be premium processing soon available for national interest waivers, which is good news. Right now it's available for extraordinary ability. They have approved it for national interest waivers, but have not implemented it yet. But that's also something that's promising that will help people obtain their green card a little bit faster. And I'll touch on the national interest waiver process here briefly. As a general overview of the U.S. immigration status, some people who are participating may be very well versed in it, some maybe not as well, but most people come in non-immigrant status, and it's alphabetical. For example, B visitors, F1 students, F2 dependents, J1 research scholars or J2 dependents, H1B specialty occupations, O1 extraordinary ability, for example. And then often people will adjust their status if they're in the United States to a permanent resident. And if it's family-based through a marriage, after 3 years, you can apply for U.S. citizenship. If it's employment-based, then after 5 years, you can apply for U.S. citizenship. So that's just a big picture overview of how most people transition through the immigration system. Oftentimes it's F1s or J1s to H's to permanent residence, or for PhD students and postdocs, often will just go directly to the green card through the national interest waiver, or if people are born in China or India, through extraordinary ability if they're extremely well qualified and don't want to wait an additional period of time until their priority date becomes current before applying for permanent residence. I will just very briefly go through issues related to OPT, F1 and J1, because those issues should be addressed by the international student. I just highly encourage PhD students, postdocs to use the international office for planning, both for CPT and OPT. The one issue to address is the STEM extension. So generally, if you are working on your OPT and you're going to try and stay with the same employer, if that employer is not enrolled in E-Verify, it could be challenging to continue to be employed there if that employer is not enrolled in E-Verify. So while you're on your first 12 months of OPT, you'll want to find out if that employer is enrolled in E-Verify, because if not, you either the employer will need to be verified or you may need to find another employer. But again, I encourage you to talk to the international office about any F1 related issues. The STEM, again, international office will address these, but the key is the timing. You'll want to make sure that you are very proactive about this, because sometimes when we get involved is when people have not been proactive, or they've waited too long, or they made mistakes. So go in early to the international office to make sure that that doesn't happen to you. J1s, very briefly, the key here is the 2-year home residence requirement. We deal with this a lot. We represent a large number of universities. And so when I say we, I work with Jim Arkell, who's also an attorney. He was a professor both in China and the United States. And also Bong Mikiabis, who was formerly the director of the International Office at Notre Dame, and also a Notre Dame Law School graduate, and another attorney, Ed McKibben, who worked at another state university. But when we get these types of issues into our office, when people are applying for permanent residence, then we see the J come up where somebody may be subject to the 2-year home residence requirement. If you are subject to the 2-year home residence requirement, you cannot change your status from a J to an H, for example, or you cannot adjust your status from a J to a permanent resident unless you either go home for 2 years to your home country, or you obtain a waiver. If you are subject to the 2-year rule because your country has a skills list, it might be a little easier to get a waiver. If you received funding from your home country or the US government, it might be a little bit challenging, but we do help people with that. So if you're in F status, an employer gives you an option to go either to J status or H-1B. H-1B is usually a better option for you, although it's often more expensive for the employer. But if there is an employer looking to put you into J status, you'll just want to be aware of the 2-year rule and what effect that could have on your ability to either change or adjust your status. H-1B is often a transition from an F or a J to permanent residence. So the H-1B is filed a lot by universities we represent. We'll help many universities with H-1Bs for tenure track faculty positions, for example, sometimes staff positions. But most of the time, most universities we represent will not often sponsor postdocs in H-1B status. So that's why often we'll help PhD students or postdocs with the national interest waivers so they can apply directly to permanent residence. We do also help some companies that are affiliated with research parks at Notre Dame, for example, University of Illinois, Urbana-Champaign. I've done work with different startup companies, Stanford and Harvard, MIT. So some of those companies also will hire PhD students and postdocs who are highly qualified under the H category. The key is if the entity is not affiliated with the university, then there's a cap and timing considerations, which I'll touch on briefly. But the H is a very good option for many people if they can find an employer willing to sponsor them. H is non-immigrant status. It's good for 3 years. You can renew it for an additional 3 years for up to 6 years. Specialty occupation is required, so the job has to require a bachelor's degree or equivalent or higher in a specific field or fields, and you have to have a degree in one of those specific fields that's required. So it's somewhat technical. You can only work for the employer that filed the H-1B petition for you. You can only work for that employer in the location for which it was approved, and you can only work in the position for which is approved. So if you are a research scientist, for example, and then that employer wants to move you into a managerial position, they need to file an amended H-1B to reflect that job change. The H also allows for dual intent. So if you have an H-1B and you're applying for a green card, then you can travel in and out of the country even while your adjustment of status is pending, as long as you have a valid H-1B visa in your passport. One thing I didn't address before I started was that there is a chat room, and at the end of the presentation, I'll be happy to answer any questions that people have to provide you with as much helpful information as possible. As I touched on briefly, H is for specialty occupation. The key here is the last bullet point, where the job titles and job descriptions are very important. So if you're going to work for a small company, you want to make sure you're well versed in how this works, or that the attorney that you bring to your employer, that your employer hires, and knows how this works to increase the probability of success. The H-1B employer has to pay at or above the prevailing wage or the actual wage. The actual wage is what's paid to other people in a similar occupation. Prevailing wage is determined by the U.S. Department of Labor. That needs to be paid for an employee in a specific position in a metropolitan statistical area. So for example, in South Bend, St. Joseph County, Indiana, there's a database, and that database is used to determine what needs to be paid, for example, for a physicist or a chemist in that specific geographic location. It protects both international employees from getting underpaid, and it also protects US employees from not having their wages undercut. That's what the Department of Labor's concerns are. But those things are are addressed before the prevailing wage and actual wage, before the H-1B petition is filed with USCIS. There is a cap on H-1Bs that are filed each year for individuals who are working for private companies. In March, there's a registration, then there's a selection process. There's only 65,000 allotted for individuals with a bachelor's. There's an additional 20,000 allotted for people who have an earned master's or higher from a U.S. institution of higher education. But every year there's at least 200,000. It's usually between 200,000 and 300,000 that are filed. So the chances of getting selected are not great. That's why we often consult with counsel, PhD students, and postdoctoral researchers about the national interest waiver process to self-petition, so that often many of our clients obtain their work authorization documents, travel documents, and often green cards before they graduate or before their OPT expires. It often actually has a far higher probability of success than going through the H-1B lottery. And it's something that you control as a PhD student or postdoc, not the employer. And the employer often doesn't have the same urgency that you do for you to obtain your green card, because employers know that once you get your green card, you're a free agent. You can do what you want and go where you want. And that's not always in the employer's best interest. So it's a good option for PhD students and postdocs, because you can get the work authorization document to work in your field, the travel document, so you don't have to get a visa. You can travel in and out on your advanced parole document. And with the permanent residence, you can often, it helps with grants, security clearance, and other things to advance your professional careers. So the H-1B is an option, but often because of the cap and the low percentage of getting one, sometimes it's not a great option. Again, there's the H-1B cap. So the April 1st, they can be filed for an October 1 start date if you're working for a private company. If you're working for a university or an institution of higher education, college, then those petitions are not subject to the cap. They can be filed at any time during the year. And if you're working for an entity that's affiliated with an institution of higher education, we represent some medical schools, for example, and hospitals are affiliated with universities, then those are often not subject to the cap. Or if you're working for a nonprofit organization that's involved primarily in research, those are also not subject to the cap. For example, we've done work for national labs. If you're in H-1B status, it's, as I mentioned, good for 3 years. If it's extended for another 3 years, that extension's not subject to the cap, so it could be filed at any time. An amendment is not subject to the cap. That could be filed at any time. So if you're moving from a research scientist to a managerial position, that could be filed by your employer at any time during the year, not subject to the cap. Or if you're changing employers, you're working at company A and company B gives you a better offer. When company B files that change of status application, it will not be subject to the cap, but you will want to make sure that that petition is approved before you leave company A, because if the one filed by company B is not approved, then you may find yourself not working for company A or company B and being out of status. So you want to be careful about the timing in terms of the filing of the petition. H-1B cap, if you're fortunate enough to work for a company, get selected, and then it's approved and it starts October 1, but your OPT expires, say, for example, on July 1st, then the H-1B cap would cover you between July 1st and October 1st. And the cap is something you'd want to talk to the international office to about if you're concerned about that transition between your OPT and an H-1B. Other options for PhD students and postdoctoral researchers who may not be selected as part of the H-1B cap. As far as non-immigrant options, TN if you're born in Canada or Mexico. There's a Schedule 1603D1 to the old North American Free Trade Agreement. It lists specific occupations. And so if your occupation is on that list, then that may be an option. It's less expensive for many employers and it's much faster than the H-1B, but does not have dual intent. So that may be an option. We've filed many of those for people. L1, intercompany transfer. If you can't find the job that you want here in the United States, then if you work for a large company in your home country, after a year, they may be able to transfer you back into the United States to work here for the same company. H3 trainee visa, we've done some work for entities in research parks, for example, where the individual can obtain training here in the US that's highly specialized, that's not available in the home country. That may be an option if you're not selected as part of the H-1B lottery. O1, extraordinary ability. This is an option for people who have a fairly strong CV with a large number of publications, citations, services as a reviewer, contributions of major significance in your field. We file a lot of these for individuals sometimes who are subject to the 2-year rule. You can't change your status, but we'll get those approved for consular processing, get the O1 visa and come back in. We also file them for quite a few physicians who are working at medical schools. H1B1 for people born in Chile and Singapore. It's similar to the H1B, but there's no cap. And E3 for individuals who are Australian citizens, again, similar to the H-1B, but no cap. Permanent residents, green cards, family-based cases. We see a lot where people come to the United States to study, get married to a US citizen, can file to adjust their status to a permanent resident. The closer the familiar relationship, the shorter the period of time to get your green card. Marriage to a US citizen, we're seeing those, so for example, students at Notre Dame married often get the temporary work card or travel document within 3 to 6 months, green card within 6 to 12 months. Employment-based cases, if you have to go through an employer, often the employer has to go through labor certification. If it's a non-teaching position, the employer has to show that there's no qualified US workers for the position. If it's a teaching position, then the employer has to show that you would be the most qualified applicant for the position after national search. And the good news for PhD students and postdocs is you can avoid the labor certification altogether through the national interest waiver and go directly to the I-140, the second stage. And if you're well qualified, also file your adjustment of status concurrently if your priority date is current. So often there's 3 stages, but for PhD students and postdocs who are qualified, either through the national interest waiver or extraordinary ability, you can go directly to the I-140 and possibly file your adjustment of status at the same time. Whether it makes sense to file at the same time, that's something that we consult with people about. Lee and I talked before. I have been coming to campus for many, many years to give this presentation, and I joke that one of my classmates is now on the U.S. Supreme Court, so that's puts a little bit more into perspective of how long I've been doing this. But I've been coming there for many years to give the presentation, and I love to do it in person, so I can actually see people. We used to meet with people beforehand and give free consultations to help people out. And so we would still gladly for free, if you want to send your CV in Google Scholar, there's Kayla@dunlaw.com, Kayla@dunlaw.com. We'd be happy to look at that and let you know if we think that you're qualified under the national interest waiver or extraordinary ability category. But again, it comes down to whether to file the NIW and adjustment of status at the same time. We'll talk to you, and we'll set up a telephone consultation for free, or sometimes a Zoom call, depending, and we'll talk to you by telephone and let you know whether we think that you're qualified or whether we think you should wait, whether you're strong enough to file the I-140 and the I-45 at the same time. And so we'd be happy to help look at your information if you want us to. Again, the self-petition, no labor certification, national interest waiver, extraordinary ability. I won't touch on investments. Some people can invest right now. That's in a kind of a holding pattern, but that's something if you are interested, you could send your information. We would look at that also at no charge. National interest waiver, it's EB2 category, employment-based second preference. I like to joke because people will often say, well, do I qualify for the EB1 category? And sometimes people might. I had this conversation yesterday with somebody, but if you weren't born in China or India and there's not a long waiting period, there's generally no reason to try and file under the EB1A extraordinary ability category because it's far more challenging to get approved under that category. One of the reasons it's more challenging is because there's what's called a final merits determination, where even if you meet 3 of the criteria, then an officer has the subjective opportunity to decide that they don't believe you're one of the few who have risen to the very top of their field of endeavor. That said, we've still had a great deal of success with extraordinary ability petitions, but generally, if you weren't born in China or India, there's not much reason to file under extraordinary ability unless maybe your work is not in the national interest or your case is more conducive to the extraordinary ability category than it is to the national interest. But they're both viable options for people who are well qualified. As I mentioned, the national interest waiver, it's a kind of shortcut to the green card. It does not require employers, so you can self-petition. We have a website, nationalinterestwaivers.com, where you can go on there. You can see different types of cases that we filed that may be similar to yours, approval notices. There's fee information and other information on there that you can look at it at your convenience that can provide you with some additional information. These are the criteria, and I see that there are a number of questions already coming on the chat, which is great. I will touch on those. Hopefully I'll touch on some of those before we even get there. But these are the criteria that the proposed endeavor has to have both substantial merit and national importance. Customarily, that's not a significant issue. Most of the work that people we see do is in the national interest. Whether somebody is well positioned to advance the proposed endeavor, they look more at, for researchers, possibly publications, citations, service as a reviewer, maybe the impact factor of the journal, the strength of your letters of recommendation. If you don't have citations, that's okay. We've had many cases approved for people who don't have citations, but if you're a researcher, it's definitely helpful to have citations, and USCIS puts a great deal of weight on Google Scholar. But you don't have to. We've had many cases approved, probably 5 I can think of just in the last week or two, with 5, 7, 12, 15 citations. Under what's called matter of Danisar in your case, it's become a little bit more flexible under the national interest waiver category. There are cases now for if you don't have citations, but maybe you've got patents, or maybe you have a business idea where there are entities that are willing to fund it, or there are venture capitalists who are willing to fund your ideas. That may also be an option under the national interest waiver category. Once, after giving a presentation at MIT, I had somebody who came to me after the presentation and never heard of this before and talked to me about it. Within 24 hours, he signed up, filed NIW adjustment of status. He got his work card, and opened up many options for him as an entrepreneur that he never would have had otherwise. And now he's incredibly successful and multimillionaire, which is nice for me to see. the success. Nice for myself and Jim and Ed and Bob to get correspondence from people to see their success, that we were able to help them in some small way, whether it's to be a successful business person, whether it's to get a tenure track faculty job, whether it's to get a great job in industry. That's best part of what we do, is to live somewhat vicariously through the success of our talented clients and help them achieve the goals that they want. And I had a client who many years ago who is now a department chair in a corner office, and I got to go visit him, which was nice to see his ascension up the ranks. And so I often see that there are PhD students and postdocs, and they're grinding hard in the lab and maybe not getting credit for the reviews that they're doing, and maybe not getting as much credit as they deserve for all the work that they're doing for their published papers. And maybe they deserve to be the first author and not getting listed as first author, but nice to see all that effort eventually paying off once they're able to get their green card through the National Justice Waiver category. But being well positioned is something that's a key component of this. And often we also need to show what your future plan is going to be. Not only what are you doing now, but what are you planning to do in the future? And then on balance, whether it's beneficial to waive the labor certification. Government wants to know, why can't the employer just go through labor certification? Here we look at your expertise, the uniqueness of your expertise, the experience that you have. Maybe you're a multidisciplinary researcher, which is fine. That the research that you're doing is highly advanced. It's not where an employer could just advertise the position in a newspaper and find somebody who can do what you do. These are questions we often get under the National Interest Waiver category. How many citations do I need? As I mentioned, there's no requirement for that. We often like to see, for people who are doing research, 10 independent citations, but there's no magic number. What else does USCIS consider? Like I touched on, they look at your publications, maybe the impact factor of the journals, maybe they'll look at the letters of recommendation. We just filed a case that had a letter from a Nobel Prize winner. That doesn't hurt your chances of success. So they'll look at, like I mentioned, patents, whether there's commercial viability to your work. You don't have to have, like I said, citations. We just got a case approved for somebody who works on COVID, but she works on clinical research. Had a master's degree, no PhD. We were able to get it approved. It was challenging, but we got it approved. So you don't have to have citations. It has to do a lot with the work that you do and how compelling your case is. And that's why we take kind of a personalized approach to talk to people, to talk through it, not just send a generic email or something, but talk through and say, okay, well, what is compelling about your case? And do the work that we were trained to do to make a compelling argument. How many letters of recommendation? We usually like to file 4 to 6 generally. Do we help with them? Yes, we do help with letters of recommendation. If we generally will send templates and work collaboratively with their clients, but if the client wants, we will draft all the letters if they'll send the CVs or biographic information of the people who will be signing the letters. Is a job offer required? No, it's not, but it's definitely helpful. Can you apply from F1 OPT status? Yes, you can. Whether you should or not is going to depend primarily on the strength of your case, and especially whether you should file the I-140, the National Interest Waiver, and the adjustment of status concurrently. Depends on the strength of your case, which we would talk to you about. Letters of support, dependent versus independent. We often like to file a mix. What's dependent? Generally, if anybody's listed on your CV, you've published with them, worked with them, they would be deemed to be dependent, who are within your circle of colleagues and collaborators. Independent, generally people who you've never worked with, who you've never collaborated with. Maybe people have cited your work or are familiar with your work, but they are not people that you've worked with closely. Is it necessary to be the first author? No, it's not. I've had many cases approved for people who have never been a first author. It's helpful, but it's not required. What can you do if you're not the first author? Sometimes we'll work on the letters to show how you were influential or important in the work, even though you were not listed as the first author. How can we have your credentials evaluated? Again, you can email them to Kayla, Kayla @dunlaw.com. She'll get back to you and potentially set up a telephone consultation with one of the attorneys in our office. Extraordinary ability. Again, often we file this primarily for people who are born in China or India. But when I am talking about people from China or India, the NIW is still a good option for people who were born in China or India who may not qualify under extraordinary ability. One of the reasons is priority dates seem to be jumping up under the EB2, particularly for India. Another reason is for people who are born in India. If you're on an H-1B and your spouse cannot work, who may be in H-4, then we may be able to, if your I-140 is approved, your priority date is not current, then your spouse in H-4 status may be able to apply for an EAD and get an employment authorization document. Plus, if you're born in India or China, you can establish your priority date earlier so that when you are qualified under EB-1A extraordinary ability, then you can jump your place in the line or the queue and use your earlier EB-2 priority date when you file your EB-1 to file your adjustment of status application if there's a backlog for EB-1A, and that has been happening at some different points in time. So the NIW is still a good option for people who were born in India or China who may not qualify under the EB-1 category at this time. Again, you have to meet 3 of the criteria. The criteria are the same as they are for an O1, but it's more challenging to get approved under the EB-1A for the green card because of this final merits determination where they have to find that you're one of the small percentage who has risen to the very top of your field of endeavor. That's where it becomes a little bit more subjective. No offer of employment is required. Again, you can self-petition. These are the criteria. Lesser nationally or internationally recognized prizes. If you won a major prize, which most people don't, then you can qualify sometimes by just having won a major prize like a Nobel Prize. But like I said, most people aren't going to qualify for that, but lesser prizes may qualify you. Memberships, it's not just if you pay, it's if you're invited. It has to be a somewhat prestigious organization to invite you. Publish material about you. If it's published on the university website or the local newspaper, not nearly as compelling as if it's in the New York Times, Wall Street Journal, or in a major publication. Judge the work of others, review work, extensive review work, having served as an editor or on an editorial review board, having served as an editor on an editorial review board, or being a program committee chair for a conference, that's going to be far more compelling than ad hoc reviews. Original scientific or scholarly work of major significance. We look at both the originality and the major significance. So major significance there, they'll focus a lot on the citations, the frequency of your citations, possibly the impact factor of the journals, who's relied upon your work. And then whether you've served in a critical or leading role. If you work at a university, likely you haven't served in a critical or leading role as a postdoc or PhD student. But if you go work for a company, you might have a higher probability of meeting that specific criterion. Adjustment of status, the last stage of the green card process. This is where you file to adjust your status from F1 or J1 or H1 to a permanent residence. It's filed for each family member, so it would be filed for spouses and children who are not born in the United States. can be filed with the I-140 at the same time if you're well qualified. So if you're an F1 student or a PhD, if you're a postdoc, you could file for yourself, your family, get your temporary work cards, travel documents in about 3 to 6 months. It used to be 3, it's more like 6. Green card possibly in about 12 months. And you would be able to have those documents maybe before you graduate or before you start looking for jobs, so that when you go to the interview process, even with your temporary work authorization document, you could state that you're legally authorized to work in the United States without sponsorship. There's a background check, medical exam prior to being approved under the adjustment of status. So we often help clients maybe who, well, we help all different types of clients, but they look at, have you ever been arrested, cited, or detained? What's your income? Have you ever been denied entry? Have you ever had any issues with regard to overstaying or problems with your status? Those things are things that can come up at your interview, so we help to prepare our clients for that. And questions. So there are a lot of questions that have come in the chat. So one question was that I'm on a J1 and I'm subject to the 2-year rule. Could I possibly get an O1? The answer is that yes, if you're qualified enough, the O1 would have to be filed by an employer on your behalf. You'd have to request consular processing, so you leave the United States, obtain that visa, and then come into the United States. But even though you obtain the O1 visa, come into the United States, you still are still subject to the 2-year rule and cannot adjust your status. There's one individual that works for a university that we work with. Been well over a decade that we've been filing O1s for this individual and still subject to the 2-year rule. So it doesn't get rid of the 2-year rule. It is a way around it, but it does not eliminate it.
Tom, are you looking in the Q&A? I'm sorry, are you looking in the Q&A section or in the chat section?
I'm looking in the chat section. Do you want me to look in the Q&A section?
The Q&A has, yeah, I think those are queued up for you, and I've cleared out the ones that were related to F&J visa questions.
All right, perfect. Thank you.
Yeah.
How long does one need to be here in order to apply for a green card? Is it easy to transition from student visa to green card? So how long do you need to be here? You don't need to be here very long at all. Though if you just entered as an F1 or a J1, for example, you have to wait at least 90 days before filing your adjustment of status application. But we get people all the time who just came into the United States, and we start the application for them immediately once they get here, file the I-140, and then file the adjustment of status after 90 days. But there's no waiting period to apply for the green card. Is it easy to transition from student visa to green card? That really depends on your qualifications. So for that individual, then you can send us your CV in Google Scholar and let you know what you think your chances are, or if you should wait for a later date to file. What exactly is a self-petition? Self-petition is you file on your own. So if you hire an attorney to do it, for example, if we do it, we prepare the petition for you, but you are the petitioner, not an employer, not a university, not a private entity. You are the petitioner, not an entity. Similar question, minimum requirements in terms of the number of years in the United States? No, there are not. How long after you get your H-1B can you file for your green card? You could file it immediately if you're qualified. Your employer may be able to file for you. That would be up to your employer. If not, then something you could petition on your own. If you're in a professional master's and if you've earned your master's, you're still eligible under the national interest waiver category because you have an advanced degree. You don't have to have a PhD. So if you want to go work for a company, either the company can sponsor you, or if you're well enough qualified, then you could potentially self-petition under the NIW category. Question here about poets, writers, people who are creative. Do they qualify under the national interest waiver category? Generally, no would be the answer. We have had people in the arts who have qualified, so I'm not going to say never. It's more challenging, but we often will get people approved under the extraordinary ability category in the arts. USCIS seems to be fairly open to extraordinary ability petitions for people in the arts. We've had people who are in music. We had a potter from Africa who was approved on the extraordinary ability petition. We have had different creative people in terms of authors and artists who have been approved. It just depends on what your level of success has been and what evidence that we can provide. So I would say it's not impossible for somebody to get approved who's creative under the national interest waiver category. It's just more difficult to get approved in general, because USCIS is used to seeing people who are cancer researchers, COVID researchers, working in nanotechnology, biotechnology, physics, chemistry, for example. So there are options for people who are in the arts, but extraordinary ability might be a better option. Question here, and so some of them I'm going through that may not be applicable to many people here, but one of the questions here is, if somebody's here on a J1 subject to the 2-year rule, can we file the I-140 here in the US and then get the green card if they have to move back to China? The answer is yes. So we could apply for the I-140 here and then request what's called consular processing to obtain your immigrant visa outside of the United States. We file for people from all over the world, many of whom who have never worked in the United States under the NIW category, directly to come in. So it is possible to obtain an NIW approval and an immigrant visa to come into the United States from abroad, or file the I-140 here, request consular processing, and then come in with an immigrant visa. Approximate cost of legal assistance through the NIW, just to get some sense. We list that on our website. So there's on our website, there's the nationalinterestwaivers.com. We are very transparent about our pricing and try to be very helpful with students and postdocs with that. Because we were students ourselves. I was a law student at Notre Dame. I worked 4 jobs while I was there, while I was a law student. So I know it's, as a PhD student and postdoc 2 year, probably not breaking the bank. So we try to have flexible payment schedules that people pay by credit card without charging additional fees. So that's on our site, and we're happy to answer questions about that. We're trying to be very transparent about our fee structures. Spousal green cards, how much does that cost? If it's somebody's a dependent, that's something that you can call and talk to us about. If you're talking about a family-based case, if you want to give us a call, we're happy to provide you that information. H-1Bs for nonprofit work. Just because you're working for a nonprofit doesn't mean that entity is going to be exempt from the cap. So unless that entity is affiliated with an institution of higher education, or it's an entity that's engaged primarily in research. So even though you're working for a nonprofit, you still have to be careful about the H-1B cap issue. There's no minimum number of years of experience required for an NIW. If you're reviewing a paper, yes, you want to have proof of that. I know a lot of times PhD students, postdocs will do review work on behalf of their advisor or boss and don't get credit for it. So you want to make sure you have proof of that, so you do get some credit for it, so that we can prove that you've served as a reviewer. Question here about the waiver of the 2-year rule. That's something that if you need assistance on, then feel free to contact us, and we'd be happy to talk to you about that and let you know if we can help you, or if that's something that you may be able to do on your own. Sometimes we work with our clients on the J1 waiver while we're going through the NIW process or the extraordinary ability process. As an F1 student, can you adjust to the DV program? Possibly, if you're selected. Sometimes we have people who have applied for the DV lottery, not been selected, but then we'll get them approved under the NIW, and just a couple clients, students who were just selected under the DV lottery and were able to push their case through very quickly to get them their green cards successfully through the DV lottery, as there's a limited window for that. So we said, congratulations for the brilliant presentation. I'd like to say thank you very much. It's always tough to gauge the reaction of people when you're talking to yourself and all you can see is your own face. So thank you for that comment. Can Indian citizens go through premium processing for the NIW? As of right now, no, but Indian citizens can use premium processing if they're eligible for EB1A. Premium processing hopefully soon will be available for NIWs, but as of right now, it has not been implemented. So if an employer is willing to go through the green card process, they can start as soon as they file the H-1B. And I have an instance where a law firm actually hired us to file the green card process while somebody was still F1 on their OPT, and we were able to get the green card while they were still in F status. So the employer does not have to wait. OPT question, I would direct that question to the international office. In terms of the timing of that, of OPT, all of those I direct to the international office. They can help you with those. F2, what can the F2 apply for work? Generally, F2s cannot work, but that's another benefit of the NIW is you can file the NIW with adjustment of status for an F1, include your dependent spouse who's in F2 status. That dependent spouse can get work authorization. We see it a lot where we have a very qualified person who's also married to a very qualified person, and then we'll have the conversation, which sometimes can be a little bit challenging to decide which of these two qualified people who are married is the most qualified and which one should be the primary applicant and the other one the derivative beneficiary. But if somebody's in F2 status and their spouse is well qualified, then that F2 can get their temporary work card at the same time as the F1 student. When should you start as a PhD student in the NIW process? It depends on how well qualified you are. So we're going to look at your credentials if you'd like to send those to us for free. General success rate for NIW based on nationality. Our success rate is extremely high. It's over 99% over the last 24 years, but it's not dependent on nationality, it's dependent on qualifications. So it really doesn't matter what country you're from, it depends on how well qualified you are. Do we suggest premium processing for EB1A? I guess it depends on how big a hurry you're in and how well qualified you are. So that's on a case-by-case basis. And how long does the NIW process take from start to finish? Usually it takes, after we've been retained, about a month for us to prepare and file everything, because it takes some time to get the letters of recommendation, 3 to 6 months to get the temporary work card, 6 to 12 months to get the green card. I think I've answered everybody's questions, unless Leah, you have other questions, or there's something else that I've missed.
No, I think you found all of the questions that were applicable. So thank you so much.
All right. Thank you very much again, Leah, for taking all the time and effort to put this together. And hopefully it was helpful to the people who participated today.
Of course. And just a reminder that we are recording this session, and we will post the recording on the issa.indy.edu website in the next week and send out a link to that. If you have any questions about your OPT or STEM, ISSA does have walk-in hours Monday, Tuesday, and Wednesdays from 2 to 4 p.m. And we offer virtual appointments on Thursdays and Fridays, and you can sign up for those on our website as well. So Tom, thank you again for the incredible information, expansive information, and please note the email that Tom provided if you do want to send in your information for a review and ask any questions there. So have a wonderful evening, everyone.
Thank you very much, Leah, and thank you everybody who attended.